All right, thank you, ladies and gentlemen, for joining us once again in the series of our estate planning. And I'm your moderator for tonight, Carol Tanjutco. I am your financial planner and advisor for many of you. Let me introduce once again our off counsel, Albert Dumawal. He holds an LLM in taxation from the New York University of Law and a JD from Touro College, where he obtained and earned a cum laude. Albert, by the way, is in the Super Lawyers New York Metro Rising Stars of 2017. So tonight is a continuation of the series that we started earlier this year, and Albert will be talking to us about planning in terms of wills. You can ask questions about trust and the basic estate planning documents, which includes healthcare proxy. Our format will be more for a Q&A. Albert has here a little bit of some slides, but we're really focused on Q&A because we want to hear what your needs are. So, Albert?
Okay, good evening, everyone. And thank you for the introduction, Carol. Yes, I'm an estate planning attorney. My primary focus is usually implementing strategies to reduce a person's estate tax exposure using different types of strategies with promissory notes and different grantor trust transactions. However, as you can see here, the state tax is going to apply to very few people. Right now, the federal exemption's a little bit over 12 million, meaning that a person can give away basically up to 12 million without incurring any federal estate tax. And for a married couple, it's 24 million. And next year, it's just going to go increase higher because inflation's been so high. Estate planning is more than just planning for estate tax. It's providing peace of mind for you and your loved ones on a broad range of issues that can arise if you become incapacitated or upon your death. It includes human planning issues such as religious considerations, health challenges, and dividing your assets fairly among your loved ones. And often the driving force for estate planning is most often financial. How will you be able to pay your bills during your incapacity? How will you be able to support your loved ones during that time too? And how would you be able to support them if you pass away suddenly? That's why estate planning and financial planning go hand in hand. And what I'll cover is just documents that person, no matter what their wealth is, documents that they should have in place to ensure that these issues are addressed and properly dealt with. However, these are just documents, and your estate planning doesn't end there. And thinking about your estate planning, their financial decisions that you need to consider, such as your overall investment plan, budgeting for the long term, and your insurance coverage, which I'll leave all that up to Carol, but you should consider disability insurance, long-term care coverage, in addition to life insurance.
Usually, the main question first is, well, do I really need estate planning? I don't have a lot of assets. And in my experience, a lot of our participants have unknowingly really a lot of assets. Maybe it's not all in cash, but we're talking of something like on the average, a retiree, for instance, has an average of 800,000, 600,000. And of course, with some of our listeners, it's a lot more than that. Plus, they have assets, they have home here in United States and in the Philippines. So I believe these are reasons, good reasons enough to have an estate plan, correct?
Yes, that's correct. Estate planning is sometimes goes beyond the financial. It's more than death too. It's thinking about what's going to happen if you're incapacitated. You have bills to pay. Who's going to pay your mortgage? Who's going to pay your heating and electric? How's that stuff going to get taken care of? It's beyond planning for death. It's also planning for what happens if you become incapacitated. And some documents, such as a revocable trust, can address those needs. A revocable trust is often seen as an alternative to a will. You could designate just fine in a revocable trust what's going to happen when you die.
So when you say revocable trust, when does it take effect? Does it take effect right away while you're alive, correct?
Well, yes, that's correct. So the general plan with a revocable trust is that a person transfers all their assets into a trust. Now, how can you do that? There's ways of dealing with that. If you have a house, you execute a deed to the trust. If it's tangible property like your furniture, you can also transfer that to your revocable trust with a general assignment of all your assets, of all your tangible property. So the idea there is that now this trust owns everything that you own, right? And what does the trust say? Trust says that the trustee holds these assets for the benefit of the person who put those assets into this trust. And by the way, the trustee is you. You're the person who put the assets in the trust, and you could serve as trustee. And it also says that the trustee is supposed to distribute as much as the income from those assets, and those assets include your savings account, your brokerage account, your checking account. So the trustee can distribute as much of that, of the income from those assets and the principal, as you as the grantor directs. So the only difference.
Hold on for a minute. If the trust is the owner, so the taxation is based on the ownership, right? So the trust is the one subject to tax, right? Unless you as the beneficiary receive the money from the trust, then that's the only time you get taxed. Is that right?
Well, the revocable trust is going to be called a grantor trust. It's going to qualify as a grantor trust because one of the key features in this type of trust is that the person who creates it can always revoke it. And that power to be able to revoke that trust subjects the person who created that trust to the tax generated from the income from those assets. So nothing changes as far as the ownership, as far as the enjoyment, the tax consequences. Nothing changes from transferring your assets to a revocable trust. Every estate plan has to stem from a strong financial foundation. And that's dealing with, the planning during your life and the planning at death to take care of, the expenses when you're incapacitated and to deal with your final expenses when you pass away, and make sure that the assets that you want to pass on are still there and they don't have to be sold to pay those expenses. And so your will is essentially just a legal document that designates where your assets should be distributed in the event of death. And from my perspective as a draftsperson, there's a lot that goes into this will. And for the client, I try to minimize it as much as possible to just the bare essentials to what they have to think about. And oftentimes they just say, I want a simple will. I just want to leave everything to my children, and I want a simple will. And often they'll get a 20-page document and they're shocked. And well, the point of a lot of the provisions that are in the wills that I draft are designed to minimize your estate expenses. So that way your executor doesn't have to go to court to figure out what to do. It's in the document. If something, and it covers all sorts of contingencies that may arise. Not all of those provisions are going to be used, but they're there just to avoid any issues with the court. The power of attorneys is kind of the cornerstone of planning for your incapacity. And it designates the person who's going to handle your finances when you're unable to do so. So in that document, you're going to name your agent, and it could be multiple people can serve at the same time. So for instance, if you have 3 children, and you don't want to offend any of your children because it might cause family rift, then you could name your 3 children, as long as you, and that might be a good idea if you think they're going to agree. But if you think that they're going to, have a deadlock, then, maybe it's best to just name one person. So other clients name their spouse and a child to serve together. And that covers their bases in case, the spouse, has issues as well as the principal, right? So you want to think about who's going to be the successors. You don't want to just name one person. You have to think about how many, who are your backups. And compensation again, if the people serving as your agent are going to be your spouse and your children, then it doesn't make sense to give them compensation, because they're going to, whatever you pay them in compensation, they're not going to get from you when you die. And they're only going to have to pay tax on the compensation they receive as your agent. There are two types of there's what's called a durable power of attorney, and that's the term in New York, and that means that the power of attorney survives incapacity, because that's the bedrock of the planning during incapacity. But there's also something called a spring power of attorney that says that the power of attorney, the agent doesn't come into office until you become incapacitated. So generally, when you sign up, this might go to, the theme of, don't rely on boilerplates. If you don't want your power of attorney to have immediate power over your assets as soon as they sign it, you might want to include a spring, what's called a spring provision in there. There's flexibility in providing that. You don't want to be too restrictive, because again, this is, this is for your planning. You're selecting people who are supposedly that you feel are trustworthy. So what I usually put in my spring provision is required a certification of two doctors who recently examined the principal in determining that person's not capable of handling their affairs. Other people want a little bit more lenient, and they require only the certification of the last doctor that examined the person. But you can make it as restrictive or as less restrictive as you want. But in any event, at least if that's a concern for you, that you don't want it to be effective immediately, any kind of provision there would be a pretty good safeguard. There are considerations that you have to go through in deciding, whether you're going to have a springing power or not, and I guess that depends on who your agent's going to be. And then another consideration is you can have a power of attorney signed by your children or your grandchildren, if they're over 18 years old, and I've done this for a couple of clients, obviously with their children's consent, where they were going off to college, and the parents had them sign a power of attorney in favor of the parents. So the parents had control over their finances while they're in college. So that's for most children, that's a good thing. The powers in the power of attorney can be specific. So they call it a statutory short form, because there's only a few pages, a few kind of line item powers that you grant on the form, but the powers that those line items correspond to are found in the statute, and each one is a few pages long. So if you sign off on all the powers on the statutory short form, don't let the short deceive you. It's actually those are very extensive, very broad powers that you're granting to someone. Now, if you're gonna enter a transaction, for instance, the sale of your house, and you don't want to be at the closing, a lot of people will sign a power of attorney for someone to represent them at the closing just to sell the house. And I've seen this at closings where they actually gave them all the powers, and or even just checked off or initialed the real estate powers. Well, even that's a little bit too much. So if you can have powers of attorney just for specific transactions, and you can also tailor it in the modification sections of that form to what specifically you want them to do. And you could carve out the powers that you don't want them to have that are granted to them under the law, and that instruction in your form will supersede the law. Another thing to consider, and we mentioned this in the context of the will, is the revocable trust, where we said that the revocable trust can serve as a substitute for your will. And for the most part, it is. And just a word about the revocable trust replacing your will. It doesn't completely replace your will, because you still need a will, because there's certain assets that you're going to have that you're not going to have in the revocable trust, especially if you receive if you're writing checks to yourself from the revocable trust. You're most likely going to have some cash on hand and some other lingering assets, even assets that you didn't even know about. Those can still be out there, and for instance, an inheritance or anything like that you weren't aware of while you're alive, that come to fruition after you die. Those become estate assets and not assets of the revocable trust. So that's why you need a will in conjunction with the revocable trust to and what that will would say is that everything that's in my estate goes over to my revocable trust. And that's what's called a pour over will. And it's kind of a backstop of, to capture assets that weren't transferred to the revocable trust during your life. And another aspect of the revocable trust is that it can also be used for planning for your incapacity. So the idea is that you transfer all your assets to your revocable trust, and the revocable trust pretty much pays for all your expenses. So if you become incapacitated, the successor trustee that you name in that revocable trust becomes the person that has control of those assets, and has these directions in the trust that says the trustee has to pay all the bills and has to provide for my well-being and beyond. So that's another document to consider for your planning for your incapacity. It's kind of a all-inclusive document, and that's kind of the benefits of having a revocable trust. Other documents that you should consider are your healthcare directives, your healthcare proxy, and your living will. And often what I don't see so the healthcare proxy designates the agent who's going to handle your medical decisions while you're incapacitated. And it's a statutory form that, you look up, the statute, and it has the form, and you copy and paste it, and that's fine. And that's what a lot of people do, but it doesn't contain a HIPAA release, and that's in a HIPAA release. HIPAA is the law that protects your privacy and keeps your medical records private. And in order for your healthcare proxy to have access to those forms, to your medical records, they may need a HIPAA release. Now, under New York law, if you're designated as a healthcare agent on their healthcare proxy, you automatically have access. You're going to be granted access to the principal's medical records. But the problem is that the healthcare proxy doesn't come into effect until the person's incapacitated. So in order to get those medical records as a healthcare proxy, a physician has to make a determination that the principal is incapacitated. Now, that takes time, and medical decisions have to be made immediately. So that's why we put in a HIPAA release in our healthcare proxies. So that way they have that authority to obtain your medical records, even while you're competent, in order to make a decision that requires urgency. And
is there a standard form for the HIPAA release?
Well, yeah, it's a statutory form. So it's if you go to the healthcare law statute, that there's a healthcare law statute that contains the form, and it's a New York State statute. So and the HIPAA is a federal law, so it's not gonna contain that HIPAA release. But a lot of companies that produce these boilerplate forms, that's where they get their healthcare proxy form. Another word on the healthcare proxy is that you can't have two healthcare agents serving at one time. You have to select one person at a time, and you should select multiple people, multiple successors in case something happens to the person you designate. And so the healthcare proxy doesn't actually, most of the time doesn't actually have the instructions that you want for your proxy to comply with. Well, it doesn't have your medical wishes, and that you often leave in what's called a living will. So the living will is really, it has the same format as the last will and testament, except that it doesn't come into effect at your death. It comes into effect while you're alive, and it's a statement of what your healthcare wishes are. And your healthcare wishes are more than just, there's a lot of thought that has to goes into that for most people. A lot of people, consider have religious concerns they want addressed in their, and with respect to their medical issues, and that's where, and you could address that in your living will. Organ donations, and you would put that in your living will, and what your instructions are for nutrition and hydration. And usually in my living will, I provide for end of life decisions. If there's no hope for recovery and death is imminent, then I usually provide that there's not going to be any feeding tubes or CPR, because those things often cause more harm than good at that stage, and to provide for your dignity, pain relief, and a peaceful death. Well, what I put in the living will, and everybody's situation is different, right? So if I'm meeting with a person who's 40 years old and I'm preparing their estate planning documents, I certainly want them to get resuscitated, right? Because they probably have a longer life ahead of them. But so what I would do is, just make sure that these are end of life decisions. Death is imminent. There's no hope for recovery. There's just no hope for recovery. And recently I've kind of came across this, in dealing, I execute a lot of wills in the hospitals and things like that. I've had a lot of nurses come into the room and sign off as witnesses. And one of the, I see this issue come up where you have a person who's frail, who's very frail, very ill, in their late 80s maybe. And the question is, this person is not eating, right? We need to get a feeding tube in there in this person, and you basically have to stick a metal pipe in a person's throat to get that in. And that's just, and then they're gonna have this tube out of their mouth or nose, and it's just not, and the result's just gonna be the same. That's that's a tough decision, but you have to really consider this person's situation, and oftentimes that's really just the end, and you just want them to be as comfortable as possible and not feel any pain, and that's often the right decision at that stage. So as far as designating your beneficiaries, one thing I would raise is if you have adult children who might be in their 50s, you have to start thinking about what would happen if you die after, you know, your child dies, you know, who's going to get your assets? It might be your grandchildren, and those grandchildren might be minors. So how would you get, you know, how are they going to receive, you know, assets that you give to them? And, you know, I know, Carol, you said a lot of people might have an estate of, you know, $500,000 or more. You know, that might be a lot to give to, you know, a 16-year-old at one shot, or even a 21-year-old at one shot. So one thing to consider is putting a trust in your will that will manage those funds for them until they reach a certain age. You know, and that would,
and assign a guardian for the funds, right?
Right. Well, you might want to think about, well, if you're the parent, then yes, you can assign a guardian, you know, in case your spouse doesn't survive you. But there are certain things that a guardian, so there's two types of guardians. There's a guardian for the person of a minor, and a guardian for the property of a minor. And you could designate the guardian for the person of the minor is basically the person who steps into the shoes as the parent of the child and is in charge of their upbringing. The guardian for the property is the person who manages the property, and a guardian for a minor's property, it has, you know, can invest the property and grow the assets, but in order to pay or distribute that money to the minor, often has to get court approval for that minor's protection. So, you know, my typical plan for dealing with children, or the younger generation, well, for minors, right? If you're going to have a guardian, is to have a guardian for the person and property, but then also have a trust that's going to receive the inheritance for that person. So you have a trustee, and would have broad provisions for applying those funds for the benefit of that minor beneficiary, without having to go to court and have that trust in existence to some time. You know, it depends on how much is going to be in that trust, but this is a time where you could actually consider some planning for that child, and, you know, say, protect them from creditors or even a bad marriage, and say that, you know, what the funds in this trust aren't going to go to the child outright until you reach certain age, like age 40, where, you know, things are a little bit settled for that person. You know, they're in you know, they should be, if they're not in a stable relationship, I mean, if they're in a relationship, it's most likely stable at that point. So the trust can terminate and distribute those assets. But along the way, you can have provisions to allow the trustee discretion in distributing assets to that person, you know, as they see fit, and as they see that a person mature and is able to handle funds. But the trustee's there to protect them too, if they sense that that person might, you know, have creditor issues, and the beneficiary might appreciate that too. So let's say you know, a minor beneficiary inherits the money, it goes to a trust. You know, they later in life they become a doctor, and they have all these, you know, liability issues, you know, for instance, from malpractice or something. You know, they'll have that trust fund that could be there in case of a rainy day.
For now, let me just speak to you about what's happening in the market as your financial planner and as your trusted advisor for many years, for many of you. So the recent months have been not what we hoped for. And looking back into the discussions, the bear market is expected to be not so good, especially in the month of October. And when I look back and reviewed what happened in 1929, because now the issue is, are we going back? Are we now in 1927? So what they're saying is, are we leading to the Great Depression of 1929? So 1929 on the S&P alone was a drop of 8%, but the Dow Jones has already a drop of 20%, which is exactly what was happening right now. Now, although my recommendation is let's keep with our long-term plan. However, this is a little bit different. What I'm doing now, just so you know, I take a look at the portfolio and set aside a specific amount for a fixed, something that can you can look at survive for at least the next 2 years. So for many of us, the baseline expenses we have, yeah, you can open your video if you want. The baseline of the expenses usually is taken care of by the Social Security, right? But we all know the Social Security is not enough. So we are still looking at our savings and our investments in the market, the stock market, or our IRAs. So let's take a look at our IRA. And for many of you, I know what we're dealing with. So I take something like 25% of the portfolio. With the average portfolio here of $1 million, we take out about 20%, 200,000, and I place it in a fixed annuity or sometimes a fixed index annuity that can earn some 6% every year. So to me, that's not bad, as long as there's like a floor where you cannot fall below. So your 100,000, take a look at 1929, 100,000, that's 8%. The following year, 100. That's not 100, right? That's 92,000, and then less 30%. The following is let's 40%. So when I calculated on a year-to-year basis, actually what you lost during what they lost during the Great Depression, it started coming back on the 4th year. But on the 4th year, remember, if your portfolio is, let's say you have 38,000 left out of 100,000 portfolio, even if the market suddenly swings back, giving you 40%, you're talking of 40% off your 38,000, not of your 100,000. So when I made a calculation, what happened during this time from 1929 and up, it actually took at least 7 to 8 years before you recoup the whole amount that you lost. So on the baseline of just 100,000, it actually took 7 years before you finally get back to your baseline of 100,000. So what's my solution? First, we take care of our bottom line. And I know for many of you, you have your Social Security plus some pension. But I know that for many of you, a great majority is in the market. As a matter of fact, I'm the one managing them in the market. So the strategy now that we see is to assign a certain amount of the portfolio and put it in the fixed. And just to make sure in the next couple of years, we're good. In the event that we need money for hospitalization, that should take care of the problem. But one word of advice too is, of course, you should have your own advisors, right? For those who are where I'm not the advisor. One caveat is you don't want to stick yourself in a long-term annuity. 7 years is way too long for me, to be honest with you. I'll pick up something like a 3 years. Now that I'm fiduciary, I'm not connected with any company, that I'm free to say what I think and recommend the company that I think might fit you. So out there, you can find 3 years annuity up to 5 years. 5 years is a long time. If you can get 5 years and it's indexed to a point where you can make 6-7%, that's good for me, because the stock market, given the longest historical values, is returning 7%. So if you can find index annuity that's going to give you 7% on the high, but 0 on the bottom line, I'll take that. In that case, you can think of assigning maybe 25% of your portfolio, but talk to your investment advisor. It's really important to secure a part of your portfolio now before we even head to what's looking like a repeat of the history, because we have reached now almost, we're at the end of September and things are not looking good. October accordingly is probably not looking, but who knows? We don't know. That's the truth. No amount of a financial analysis can tell anyone that something for sure is going to happen. So we are now taking this security role. Think long term, however, in your planning, put a certain bucket for the short term because it's immediate. And then you put a certain bucket for the midterm. Midterm is like 7 to 10 years. And then, yeah, sure, we can go back to our Roth conversions. One of the tax efficient ways that I have always reminded everybody before the year ends, take advantage of the IRS very high deduction, right? The exemptions right now. Take advantage and do some Roth conversions so that the tax-free money is your last bucket of money that you want to spend. Maybe it's the legacy money that you want to leave to your children so that they don't have to worry about paying taxes. And also remember the Secure Act, the changes that happen in the Secure Act, where the IRA right now, it cannot be inherited by your children as their own IRA. They have to pay taxes within 10 years. If it's a spouse, you're okay. The spouse can still treat your IRA as their own IRA. However, under the Secure Act, there is now 10 years for children who are inheriting your IRA. So think about leaving $1 million of IRA to your children. They're going to get taxed. And remember, our children are at the high tax bracket because they're doing well, they're working, and they have a higher bracket, tax bracket than us. So by the time they get our IRA, they're probably paying a lot more. So think about it. Pay the tax today and don't let them pay a higher tax tomorrow. So that's just one of my reminders. So for many of you, we will talk one-on-one because I really can't go into the details of these investment portfolios. It's just that I was hoping to share with you some analysis that I did, and I want to go through with the numbers with you, but I couldn't. We may have to hold another meeting for this, but I'll have to make sure that the screen is working so I can share with you some of my personal analysis. But one thing that I want to tell you now is I'm doing now with an algorithm trading, and I'm seriously studying algorithm. So in the next meeting, I can share more of the tactical analysis with you. Well, thank you so much for joining us. If you do have a question, please ask Albert right now. But for many of you, I emailed you, copy the email of Albert so you know his email address, and you can always ask me his telephone number. I'll shoot it to you in the text messaging.
Yeah,
Albert, anything else?
Also talk about the Roth conversions and leaving your retirement benefits to a trust, a conduit trust, and you know I'm always happy to discuss those things too. It all goes hand in hand with the estate planning. So thank you, Karen, for having me, and thank you everyone for.
Good night, everyone, and thank you.